Well, good afternoon, everyone. Thank you so much for joining. I'm Karen Hackett, Director of Development Events here at Montclair State University, and it's a pleasure to be with you. Thanks for joining for this webinar. I am joined by my colleague, Ellie Santoni, Senior Director of Gift Planning, and I'll turn it to her to say a few words before we begin the presentation. Ellie?
Sure. I just want to welcome everybody and thank you for coming. But I want to take just a few seconds to thank our volunteer panelists, Ryann and Deidre, who can be with us here today, but she's here in spirit. And I just want to say we have like a 10-year relationship with Porzio, and we are very grateful to have them as our partner. And last but not least, I want to thank Karen for being my partner and putting this together and for doing an amazing job. Welcome, everybody.
Thanks, Ellie. So just a few housekeeping notes before we get started. We hope you find this webinar helpful and informative, of course. And feel free to ask questions throughout the presentation by using the chat or the Q&A feature. At this time, I'd like to introduce our presenter, Ryann Siclari, counsel at Porzio, Bromberg, and Newman. Welcome, Ryann.
Thank you, guys. I appreciate it. So today I'm going to be talking about maximizing your money through wealth and tax strategies and charitable giving. So our goal today is really to talk about ways to make sure that your wealth supports your family and your goals, and that all of these pieces of the estate planning puzzle align to support exactly what your values are, and to support your family and your communities in some tax advantageous ways. So we're delighted to be here today to share some of our knowledge so you can consider how you might want to adjust your estate plan going forward. So I'd like to first thank Montclair State University for allowing us to be here to support their community. So a little bit about Porzio's wealth preservation team. We focus on the needs of families and individuals and business owners. Our team is attorneys, paralegals, fiduciary specialists, administrative members. So we have a pretty wide team, and our goal is really to be client-centric. We're there to help you with your particular goals. So my background in particular is I am a certified elder law attorney, and I have my master's of law specializing specifically in the area of elder law. So my focus really is asset preservation for families. So today, what my goal is for the presentation is to help you understand ways that you can plan for your wealth to support you as you age, plan for your wealth to provide security to your family when you're no longer here, and planning to use your wealth to support your community through charitable giving. But before we start talking about each one of these areas, I want to take a few polls because I don't have a great knowledge of who's in the audience because I can't see you guys. You can see me, I can't see you. So I want to get a better knowledge of who's here. So I'm going to have them publish our first poll. The first poll is, what age bracket are you in? Are you over 75? Are you 55 to 75? 40 to 55, 25 to 40, or under 25? I guess I'll answer too, it's on my screen. So once you have taken the poll, I think we can give it a couple seconds. We'll be able to publish the results so that each one of us can kind of get an idea of who's out there today. And we can focus our talk on what might be of most interest to the people in the audience. So Karen, are you able to publish those results?
Sure can.
Great. So we've got 12% are over 75, 82% are between 55 and 75, and we have 6% in the 40 to 55 year range. So that's great information for me. It helps me understand where to focus my efforts today. And I think that the vast majority of you in that 55 to 75 year bracket are going to find this very, very useful. So the next poll that we have is, why did you sign up for this webinar today? Did you want to learn about tax savings? Did you want to learn about protecting your assets? Were you really here because you're interested about charitable giving? Or was it a combination of all of those things? So, we have a little bit in today's presentation about each one of these topics, but I want to be able to better understand where to focus my time, and maybe I can add a little bit of tidbits here and there based on what interests most of you. So, Karen, I don't know if we've got our results. Oh, there we go. So 26% about tax savings, 32% about protecting assets, 11% about charitable giving, and 58% all of the above. So that's great. So each one of you are going to get something useful out of today's webinar. So the last two polls I have really kind of go hand in hand. Do you have an estate plan or will is the first question. If we could publish that one. And this should be pretty quick. Either you have it or you don't have it. So it's a yes or no question. We should be able to get the results of that one pretty quickly. And we'll publish those for everybody to see. Okay, so we're real close to 50-50 here on who does and does not have a will in this group, an estate plan in this group. That's very interesting to me. So the next question is, if you answered yes to you have an estate plan, have you discussed those plans with your loved ones? Do they know what you're interested in or not? Because, the vast majority of people I find, they have their estate plans in place, but they never really talk to their family about them. So I'm interested to see what the result here is. Karen, do we have our results? Okay, so of the people who have the estate plans in place, about 50-50 on whether they've discussed it with anybody or not. So that's really helpful information for me in moving forward on the presentation today. So now that I have a better idea of our audience, let's talk about our starting points. So for anyone looking to engage in estate planning or looking to revamp their estate plan or make sure that it accomplishes what they're trying to accomplish, there's really two preliminary questions I think that are valuable to ask. Who do you want to benefit? Or in some cases, not benefit? And what are your assets? So we'll talk about each one of these in turn. So who is your family can actually be quite broad, right? Family doesn't just mean my spouse and my children. Family could mean your grandchildren, your parents, your siblings, your pets, partners, friends, or community. Now, community can include charitable organizations that support causes that you find valuable. Those causes may be directly tied to your community, such as supporting your alma mater, for example, or more broad, such as maybe you want to support a cancer foundation. But no matter who you want to support, having the understanding at the outset of who you want to leave money or assets to can help guide how you do those things. So in addition to identifying the who we're going to benefit, we need to identify the what we're going to benefit them with. So what assets are we looking at when we're talking about benefiting our family and community and friends? So really it's everything you have. Your tangible personal property, collections, cars, your real estate. You might have a portfolio where you have your primary residence and rental properties, bank accounts, so checking, savings, CDs, money markets, investment accounts like brokerage accounts or individual stocks, retirement accounts, 401ks, IRAs, life insurance. That's a big one that people kind of forget about because it doesn't benefit you right now, but it's something that may benefit individuals after you pass away. You might have a business. You might get special benefits through your employment, and you might have digital assets as well. So when we're talking about assets, it's important to broaden your scope of what you're looking at. We're not just looking at one brokerage account or really even looking at things in individual perspective necessarily. We want to look at it holistically. We want to look at all of your assets when we're analyzing how best to set up the estate plan to benefit the who. The assets are really important. And we're going to talk in a little bit about how we can utilize certain assets to benefit certain individuals in a more tax advantageous way. So we know who you want to benefit and we know what assets we are working with. The next question is, what are the goals? When we're planning ahead, there are tons of legal and financial considerations. So we use estate planning techniques and strategies to protect against some of these things you see on the screen here. We can take advantage of taxes. We can prevent some beneficiary problems. Maybe you have a beneficiary who's a spendthrift. They might waste money on things that are frivolous. They want to go get their inheritance and go buy a Ferrari. Or maybe they have an unstable marriage. Or maybe they've been sued for something, or maybe they have bankruptcy problems. So when you look at beneficiary problems, that can be quite broad. Long-term care costs. Quite honestly, I've seen more families have their wealth reduced through the significant cost of long-term care expenses, which we're going to talk about today, way before we have to worry about taxes. So, we do think about the issues we have while we're living, not just what happens when we pass away when it comes to estate planning. We're concerned about financial mismanagement. Is the person we're appointing to handle our assets doing a good job? We want to plan for those types of things. And there may be outside influences like, again, maybe a wayward spouse of a child who you don't necessarily get along with or agree with their way of handling things. So, one question someone posted in the chats is, by digital assets, do you mean Bitcoin? Not necessarily. I mean, Bitcoin could be considered a digital asset, but you might be talking about login information is another way to, it's valuable to have those things. So digital assets is more broad than just like Bitcoin, for example. One second, my screen's being slow. Here we go. So why do we want to engage in estate planning and asset protection? So we know what happens to our assets when we age. Are they being used in a way we want? Are they not being used in a way we want? Did we work all our lives for our assets to go to the cost of long-term care? And then what happens when we die? Did we want our assets to go towards some extravagant expenses our child decided they could afford once they received an inheritance? That may not be what we want. So we work hard to benefit those individuals that we choose. And that's two paths. A lifetime, we need to be concerned about things that would deplete our wealth during life. And then again at death. So there are two things we must consider when we're talking about estate planning. So we're going to start by talking about the lifetime issues, and then we'll transition to the death issues. So what types of concerns are we focused on when we're talking about lifetime or aging issues? Really, there's two. Capacity, so the ability to make your own legal, financial, and medical decisions. And there's cost of care. What happens if I need a home health aide or I need a nursing home down the road? So when we're talking about legal capacity, and again, it's the capacity to make decisions for yourself. So the rule of thumb is that if you're over 18, you have legal capacity unless a court determines that you do not have capacity. Now, I'm sure every single one of us in this room can probably think of a person or persons in their lives that they say, I don't think this person has the ability to make these decisions, but they were never determined incapacitated by a court. That's really common. That's why we have various substituted capacity documents. So a lot of times when people plan in advance, they don't need to go to court to have a capacity determination because they've made plans to address, well, what happens if I'm not able to handle my own affairs? So that way they've already addressed this and don't have to take that extra step of going to court. And we really do this via two primary documents: the power of attorney for financial decisions and the medical power of attorney or advance directive for medical decisions. So if we have those two documents, we can avoid those other two circles down at the bottom there, the guardianship and the conservatorship, which we're going to talk about what happens in those situations if you don't have your documents in place. I'm going to talk about each one in turn. So the first document we have is the durable power of attorney for finances. The reason we have this document is that we get to decide while we're capable, right? If I have capacity to make decisions for myself, I can execute a power of attorney, and I get to name who I want to manage my financial affairs in the event I cannot manage them for myself. So because this is simply drafting a legal document and signing a legal document, it's much more inexpensive than having to go through the court process of a capacity determination. And it's voluntary, meaning I get to decide if I want one, number one, and who I want, rather than letting a court decide who should make decisions for me. They are also revocable, meaning that you can change your power of attorney at any time. If you named your two children as co-agents and one of them's not making decisions financially that you would appreciate or respect for your own finances, then you can say, I'm revoking this power of attorney and putting a new one with just my one child on there. So you have complete flexibility with your power of attorney, provided you continue to have capacity. Now, power of attorneys, they are what we call durable, meaning that they continue to be effective even after you lose capacity. So if you had capacity when you signed it, but then later develop Alzheimer's, if it's a durable power of attorney, it's still valid. Now, for the longest time, I would do these presentations and I would say, I've never in my career seen a power of attorney that's not durable. Well, a couple months ago, I did see a power of attorney that was not durable. The woman had developed Alzheimer's and we could no longer use the power of attorney that she signed because it was not durable. So it's important to know what your power of attorney is doing for you. And they come in two flavors. They come in the immediate or the springing. Now, an immediate power of attorney means that the moment you sign it, it's effective. Your agent can take it and go to the bank and do things on your behalf. Whereas a springing power of attorney only comes into effect once two doctors determine that you are incapacitated. Now, that springing power of attorney sounds really great, right? It's, oh, well, if I don't need it, they don't get to use it. That makes a lot of sense. The problem is actually using the springing power of attorney when the time comes. So in my experience, the issue is, number one, getting doctors to certify in writing that you are now incapacitated. That can be very challenging. And number two is, even if you do get those letters, the bank often says they don't like the way the letter is written. It's not thorough enough. They don't want to accept that the person is incapacitated. And there's also some gray area, right? Where someone needs a lot of help, but may not be incapacitated. So and again, this is practitioner to practitioner specific, but I generally don't prefer springing power of attorneys for those reasons. I think they often lead to a guardianship. Whereas the immediate power of attorney, your concerns, and you don't even have to tell me, I know what you're worried about. You're worried about someone taking advantage of you. They're going out and using the power of attorney in a way that they should not. Well, there are a couple of ways to protect against that. Number one is we often hold the power of attorney in our vault, the original, so that way if the person needs to access it, they have to give us a call first in order to get the original. So that's one path that people sometimes take. Secondarily, you don't have to tell them, well, you don't have to give it to them, right? You can hold on to it yourself. You would tell your agent where you keep it. So that way, if they need to use it, they can get to it, but you don't have to give it to them just because you've appointed them. And that really all comes down to who do you select as your agent or your attorney, in fact. So you want to pick someone you trust. You can't just say, well, I'm going to pick my oldest child because they're your oldest if that person is not financially sound. So putting some time and thought into your agents is the best thing you can do when it comes to protecting yourself against wayward individuals. We also have our medical power of attorney or healthcare directive. And again, this allows your agent to make medical decisions for you in the event you are not able to make those decisions for yourself. So, do you want life-sustaining treatment in the event you are in a terminal, incurable condition? Do you want artificial hydration, artificial nutrition, a ventilator? Those are the types of decisions that you would put in your medical directive. So it really comes in two parts. There's an instruction directive. What do you want them to do for you? And there is an appointment directive. Who do you want to make those medical decisions for you? So, and again, it's inexpensive to do this, and it's voluntary. You don't have to pick someone you don't want to pick, right? So that if you don't have one of these in place and a medical decision needs to be made, let's say you have two children and one says yes, one says no. Now what do? We don't have a directive saying who we want to make the decisions. We don't have the types of decisions we would want. Now we go to court. So it's very inexpensive to avoid the court process and the fighting. But one of the most important things I would say is just putting on the advance directive, like you do or do not want life-sustaining treatment, is helpful, but not as helpful as filling out the paperwork and having a conversation with your agent. One of the most heart-wrenching things that we as attorneys see in this area are family members who say, well, it says that she doesn't want life-sustaining treatment, but I think this is a gray area. I don't know what she would have wanted. So I do think there's a lot of value for the person you're appointing by simply telling them what you want. You know, have a cocktail and tell them what you want and move along. It doesn't need to necessarily be a long drawn out conversation, but it's certainly something that you should discuss. So if the time comes, they're not in a challenging position. So this is a great question that I got in the chat. Can two people be medical POA, such as your daughter and your husband? So the answer to that is no. In New Jersey, you cannot have co-medical agents. You can have co-financial agents, but not co-medical agents. One person has to be the ultimate decision maker. What you can do is say that you direct your agent to talk to your child or your spouse. If you pick someone, you can say that you want them to have the conversation, but at some point, one of them has to be the ultimate decision maker. Because I mean, it's practically speaking, if there's a disagreement, now what? You're in this hospital bed with no decision being made. So it's from a public policy perspective, they don't want that. So only one in succession. So it could be your husband first. And if your husband's unable to make that decision, then your daughter would be backup. But while your husband's ready, willing, and able to make the decision, your daughter really has no say in that, depending on how your directive is written. That was a great question. Thank you. So what happens if we don't have these documents and we become incapacitated? Well, that's what we have the guardianship for. The guardianship process, it's expensive, right? Because you have to get 2 doctors to certify that you are incapable of handling your financial and medical affairs. Sometimes you can get your doctors to do it. Sometimes you have to pay doctors who specifically do these types of evaluations. You have to hire a lawyer who then files the complaint with the court. Then the court appoints another lawyer to represent the alleged incapacitated person. And if you're really lucky, your children or others don't think that the person who brought the guardianship should be the guardian, and they get lawyers. So now you've got a 3-ring circus of lawyers fighting over, does the person have capacity or not? Who should be their guardian? It can get extremely expensive. It also puts you out there in a very uncomfortable way where the court and attorneys are analyzing whether you have the ability to make decisions for yourself or not, who should be making those decisions, what should happen to your assets. And so it can be a very uncomfortable and expensive process, because there's also court hearing. We have testimony. The doctors can testify, the family members can testify. And then even assuming the court does what we think they should do, right? We think they should appoint your spouse as your guardian. Well, that person now has to file annual reports. So they have to do a report of well-being. Have you been to the doctor? What's changed about your medical situation? Where are you living? They also have to do an accounting of your assets. So where's the money going? What have they been spending it on? It can be a little bit cumbersome. So I do encourage you to consider having your substitute decision maker documents, your power of attorney and your advance directive or medical power of attorney, so that you don't have to go through a guardianship in the event you become incapacitated. So with that, we're going to continue talking about our aging related issues, right? We talked about capacity and the problems that can go along with that while we're alive. Now we're going to talk about long-term care costs. So I'm sure it's no surprise to anyone on this call that it's expensive as you age and you need long-term care. So a home health aide in New Jersey averages around $5,700 a month. Adult daycare is $2,000. Assisted living is $6,500, and a skilled nursing facility is about $12,100 a month. A month. It's very expensive, and we have an aging population. More and more people are needing long-term care. So it's something we need to be aware of, because as I said early on in the presentation, families can get wiped out by this expense because it's so high every single month. So when we're talking about issues in aging, there's really a continuum of issues we need to consider. Financial issues, medical issues, residential. Are we home? Are we in a nursing facility? Competency, which we just spoke about, and emotional. This affects the family. This isn't just the person who's aging, but everyone who's trying to make sure that they're taken care of. So there are different ways we can talk about long-term care. I like to start with Medicare, because Medicare is really a misnomer. It doesn't pay for long-term care. So Medicare is essentially health insurance that you have funded through payroll deductions during your working or your spouse's working career. If you're 65 or older, you're eligible for Medicare. You can have Medicare Part A, Medicare Part B. You can have alternatively a Medicare Part C plan. You have prescription drug coverage under your Medicare Part D, but it's really intended to be health insurance. it only covers a limited amount of skilled nursing care. So let me give you an example. If I fall and break my hip and go to the hospital and then get discharged to a nursing facility for skilled rehabilitation relating to my hip, that's something Medicare will cover for up to 100 days. Now, you're not guaranteed 100 days, but you can get up to 100 days. But that's it. Once you get to day 101 and beyond, that's it. Medicare does not cover it. So Medicare is not for long-term care. It's for short-term rehabilitation. And so when I'm talking about long-term care, what I'm really talking about is assistance with your regular activities of daily living: bathing, dressing, transferring, toileting, eating. Those are activities of daily living. So if you are in the nursing facility, not because you're getting rehab on your hip, but because you have a lot of difficulty getting in and out of bed or taking a shower by yourself, that is the activities of daily living that lead to what's called custodial care, either through a home health aide or a skilled nursing facility who's providing that custodial care. So there's several settings that you can receive long-term care in. We've got home care, which is, a home health aide coming to you; assisted living facility, which is kind of a middle ground where you typically have an apartment where you still have assistance on a kind of as needed basis. And then you have skilled nursing or a nursing home, which is a higher level of care. And you also have continuing care retirement communities, or CCRCs. And those typically involve, basically you start in an independent apartment, and as your care needs increase, you move through the different care settings. So you'd go from an independent apartment to an assisted living apartment to the skilled nursing facility, all on the same campus. So you're not moving around as your care needs change. So that's what a CCRC is. So we talked about long-term care, but what we haven't talked about is how do we pay for long-term care? And there's really 5 ways. The private pay, which is using your own money; Medicare, which we talked about, is very limited to skilled rehabilitation for up to 100 days. Long-term care insurance can be a very valuable way to preserve your assets in conjunction with some of the estate planning techniques that I'm going to talk about. Veterans benefits to a limited degree. And really, the payer of last resort is Medicaid. So how do we get to a point where we're not because Medicare is not going to help us. Long-term care insurance, unless you've got it when you need it, it's not going to help you. And veterans benefits is very limited. So we're really looking at private pay or Medicaid. So how do we get you eligible for Medicaid so you don't have to use your money? That's where I come in. So Medicaid is the payer of last resort. It's needs-based. You need to need Medicaid in order to qualify for Medicaid. And Medicaid here in New Jersey does cover nursing facilities, assisted living facilities, and home care to a limited degree. You're never going to get 24/7 home health aide assistance on Medicaid. You're just not, it's not an option here in New Jersey. I think most people get in the 40-hour a week or less range. But in order to qualify, there's really 3 tests we look at. There's an income test, an asset test, and a clinical test. So in order to be income eligible, the applicant, so when we're talking about a married couple, we're only looking at the applicant for this particular test. The applicant's income must be below the income cap, which is $2,523 a month in 2022. If the applicant's gross income exceeds that cap, it's not to say there's nothing we can do. We have to just take some extra steps in the form of establishing what's called a qualified income trust. We don't care what I'll call the community spouse, what their income is. We only care about what the applicant spouse's income is. And that's really important. I can use that rule to help preserve assets. So one takeaway from long-term care protection that I want you to, if you're a married couple, write this down. If you are married and one of you needs long-term care, seek out the assistance of an elder law attorney right away, because the rules allow us to essentially protect all of the assets for a community spouse. So if one of you needs long-term care, come see me or another experienced elder law attorney. So that's the income limit. The asset limit for just the applicant, so a single person, is $2,000. And I'm going to talk in a moment about the rules for a couple. So, but just for a single person, it's $2,000. And when we're talking about assets, we're talking about everything. Your retirement accounts, your spouse's retirement accounts, your house, your cars, your CDs, your money markets, everything. We look at everything. There are a few exemptions, which I'm going to talk about, but start with the general rule of thumb that we look at everything. Cash value of life insurance. That's one people forget a lot. But then you also have to be clinically eligible, meaning medically you must need this. So you need assistance with 3 activities of daily living. So there are, as I said before, certain exemptions. So if your home is exempt, as long as you live there. So they're not going to count it towards your eligibility as long as you or your spouse live there. But that doesn't mean it's not going to be subject to estate recovery when you pass away. So they'll let you be eligible, but then they expect you to sell it and pay them back after you pass away. So there are so can you become eligible owning a house? Absolutely. Should we consider some asset protection strategies so we don't have to pay it on the back end? Absolutely. So when it comes to a married couple, if you do no planning, so you don't go see the elder law attorney, you can keep 1/2 of your countable assets up to $137,400. So I'll give you an example. I have a couple, they have a house and they have $250,000 of other assets, retirement accounts, life insurance, checking accounts, $250,000. They can keep $125,000, half, plus the house, and become eligible for Medicaid. We can also do, again, there's asset protection strategies that we can use. And I want to just move on to that really quick. So Medicaid has what's called the 5-year look back. So when you apply for Medicaid, they ask for 5 years of your account statements. So from the date you're looking to become eligible, 5 years prior to that, they want to see every account statement for every account you've had during that time period. So they can see if you've transferred or given away any assets to anyone else in the 5 years immediately preceding the application. Well, we can take that and use it to our advantage by setting up irrevocable trusts prior to the 5 years. So if you are a person who's in that 55 to 75 year group, you should certainly consider planning before the 5 years, right? If you need long-term care 5 years from now, we can protect more of your assets if we plan before that 5 years. So when it comes to Medicaid, if you do give away assets or contribute them to a trust during the 5-year clock, immediately prior, they'll assess you a transfer penalty. So basically what they do is they look at your records and they say, okay, during the last 5 years, you gave away $100,000. So what they'll do is they'll take the $100,000, divide it by the transfer penalty divisor, which is currently $11,387.70, and that generates a number of days that you're ineligible for Medicaid, which is challenging because the penalty doesn't start until you're otherwise eligible. So what that means, you qualify clinically, you qualify income, and you qualify with assets, meaning you got $2,000. You apply for Medicaid, they assess you a 10-month transfer penalty, but you only have $2,000. Who's going to pay for your long-term care during that 10 months? That's very challenging. So the transfer penalty is intended to require that someone either return the money or that they pay for your cost of care. So the transfer penalty is something we have to plan around. And we do that with the 5-year planning that we just mentioned, or crisis planning. So I want to give you guys an example of what I mean by crisis planning, because I think I get the second main point I want you guys to take away from this is that don't assume that if you haven't done any pre-planning, right? You didn't plan before the 5 years before you needed it, but now you need long-term care. Don't assume there's nothing you can do to protect your assets at that point. There's, in this simple example, the person has 3 options. They can spend their money on their cost of care until they have nothing left. That's spending down. That's the simplest way to obtain Medicaid eligibility. Just spend your assets on your cost of care until you have nothing left, then apply. Or we could do, again, the person's in a nursing home right now. I know how much it's going to cost me every month, $12,151 a month. They have $3,500 a month of income. That means I'm short $8,600 a month. For 60 months, I know how much that's going to cost me, $520,000 just about. So if I have $750 and I need $520 to cover my 60 months cost of care, I can give away $230,000 and become eligible for Medicaid 5 years later. That's one way to do it. Even more complex, I can utilize a Medicaid compliant annuity in a crisis situation in order to make a gift, which generates a transfer penalty, and then use the rest of my money to cover the transfer penalty. So I could spend a whole hour just talking about this slide. So I don't expect you to fully understand this at all. But what I want you to take away from this is that don't assume there's nothing you can do if you are in a crisis, need care right now situation. This example is just meant to show you that we have options on protecting money, even in a crisis situation. So I see a couple of questions in the chat here. So one of the questions, what protections are available for people who aren't married? And that's where we get into like our 5-year trust. You can plan in advance. You can establish a trust, transfer assets to it, and 5 years after that transfer, they're no longer subject to your cost of care. So that is a great way for both single and married people to plan, but you got to do it in advance. And again, even in a crisis situation for a single person, there's things we can do. We can gift to your children and use an annuity to cover the gift. So there's things we can do, single people or married people. It's important to know that, but the best way to get protection is planning in advance. So with an example of an asset that I fund the 5-year trust with all the time is your primary residence. You title your primary residence to the trust, you wait 5 years, and it's no longer subject to your cost of care or estate recovery if both of you should be long-term care or pass away. What's the downside to you? Well, you continue to live there, you continue to pay the bills. There's not a great downside to it. So even if you don't want to protect other assets, starting with your primary residence is a great way to do it. And just to circle back for a second on kind of what we started with, why are we doing asset protection? We want to make sure we're avoiding these things that we don't want to have happen to our asset. And we want to benefit those that we want to benefit, our children, our families, our friends, our community. We can do that with asset protection planning. So somebody had asked if I could share more information on a disabled or caregiver child. Those are 2 ways to transfer assets that Medicaid allows us to do it. So a disabled child, Medicaid allows us to transfer assets. So let's hypothetically, I need long-term care. If I have a child who's disabled, I can take all of my assets, transfer them to the disabled child, and I can obtain Medicaid immediately with no transfer penalties. So it's a strategy that's only available to people who have children who are disabled. So if you fall into that category, certainly talk to an elder law attorney. The other one that was brought up in the chat was the caregiver child exemption. That is a very specific exemption in the Medicaid rules that says that if you have a child who has provided your care for 2 years immediately preceding the Medicaid application, that you can transfer the primary residence to that child and it not be penalized. Now, that is a very challenging exemption to use here in New Jersey. The state doesn't like it, so they challenge it quite often. So you have to have extremely extensive medical records to support that the person would have been in a skilled nursing facility, but for the care that that child provided. So it can be very challenging to get that exemption, but it does exist. And again, these are case-by-case things, right? If you came to me and said, I need long-term care, how can I protect my assets? Or I'm concerned about long-term care, how can I protect my assets? These are things that we would analyze on an individual one-on-one basis. So now that we have talked about the aging aspect of things, I want to talk about just estate planning more generally. So is your estate plan complete? So all estate plans, my estate plan, the guy next door's estate plan, all of your estate plans must have a last will and testament, a general durable power of attorney, which we talked about, and a healthcare power of attorney or living will or advance directive, which again, we talked about. Some plans may have a revocable trust. For example, if you own real estate in multiple different states, you should have a revocable trust. Because if you don't and you pass away, not only do you have to probate your will here in New Jersey, but you would have to probate your will in every other state that you own real estate. So revocable trusts they are very useful in certain situations. And some people also have an irrevocable trust. Example being asset protection for long-term care. I might have an irrevocable trust. Getting assets out of your taxable estate because you have a taxable estate. We want to minimize our estate taxes. You might have an irrevocable trust. You have a large life insurance policy. You might have an irrevocable trust. You have a disabled child. You might have an irrevocable trust for that child. So there's lots of different types of irrevocable trusts. They're not one size fits all in any way, shape, or form. So one of the questions is, can an irrevocable trust be challenged? So anything can be challenged, right? So can it be challenged? Absolutely. People go to court for all kinds of crazy reasons all the time. The real question is, what is the likelihood of success if they challenge it? And it depends on a lot of individual circumstances, right? So if you had capacity when you signed the irrevocable trust, it's going to be very difficult for them to challenge it. They would have to have a reason to challenge it, not just because they don't like, you're benefiting charity when the children wanted to be benefit. Just because they don't like what you're doing is not enough to challenge an irrevocable trust. So in addition to, do you have these documents? One of the questions is are they current? When was the last time you looked at your will? Have you moved states? Is it 5 or 10 years old? Because tax laws change. I don't know if you guys noticed, Congress does all kinds of stuff. So you may want to get it reviewed, even if it may not mean you need to change anything, but you might. Tax laws change. Did you get married? Did you get divorced? Did you change jobs? Did you have family changes? Do you have new children, new grandchildren? Do you have a child who did some crazy stuff and maybe we need to reconsider. Maybe they need assets held in a trust that originally you didn't have it. Are your executors right? I'll tell you a story of my own family. My mother-in-law did her will when my husband was 2, 3, 4 years old. He's almost 40 now. And she and I looked at it and I said, maybe you should consider the fact that your son is an attorney now. He might be a good executor as opposed to his, 89-year-old aunt. So, there's certain things that, time changes things. So I would say that if you haven't reviewed it, you should certainly consider reviewing it. So trusts in an estate plan. So what is a trust? I keep using this term, but I didn't fully explain it. So a trust is kind of like a small business. You have this entity that assets can be titled to, and then you have people who control the entity. So the person who creates the trust is the grantor. They're kind of like the founder of the business. Then you have the trustee who can manage the assets held by the trust. That's kind of like the president of the business. And then you have the beneficiaries of the trust. So they're kind of like the shareholders who can benefit from the money being held in the trust. That's all a trust is. And the trust agreement says how the trustee can use the money to benefit the beneficiaries. So you can have trusts that are standalone. All it is a trust document. Or you can have a trust that's created within a will. And there are various situations where we use one versus the other. Most commonly, if you're talking about asset protection, we're talking about standalone trusts. They're a separate document from your will. Do you know where your original will is? Because I'll tell you what, it's very hard to probate a copy. Not only is it hard, you actually have to go to court and file a complaint and try to prove that you didn't purposely get rid of the original. It's very difficult if you don't have an original of your will. So if you don't have it, make sure you know who does. And often if you don't have it, it's the lawyer. So just make sure if you haven't, spoken to the person that's holding your will in a while, touch base. It doesn't hurt. Have you updated your tax planning? As we said, Congress changes those laws. Did you make any specific distributions? I want to leave $20,000 to each of my grandchildren. I want to leave my house to one of my children. Do those things still make sense? Did you take into consideration your pets? What happens to them? Who's going to care for them, and how financially are they going to do that? How is your money being distributed? You have the ultimate flexibility. I'll give myself an example. My daughter's 3 years old. I have a trust in my will that says that if something happens to me, the money for her is held in trust with a trustee who manages it for her. She can get a distribution at 25, 30, and 35 years old. The trustee can make distributions for important things like college. But if she says, hey, trustee, I'm 20, I want money for that Ferrari, the trustee is going to say, no, you're not getting it. So you have the flexibility to decide how that's structured, and it might be different for different beneficiaries. You've got to decide who your executor is, who your guardian is, who your trustee. These are all decisions that you have the flexibility of deciding in your estate planning documents. So as part of your estate plan checkup, it's really important to understand your assets and how they're titled. So joint assets, you hold the asset husband and wife. If something happens to one of them, it automatically passes to the survivor. I have a joint account with my brother. If something happens to me, it automatically passes to my brother. Do I want that? It's important to know that you're taking into consideration what's happening by having this joint account. Maybe my brother's my power of attorney and I want him to have access to my money, but instead of putting him on as a joint owner, maybe we add him as a power of attorney so that he can handle the assets on my behalf, but doesn't have any ownership interest. You know, what happens a lot of times in my world, I do Medicaid, right? I have more applications than I could tell you where a child added mom or dad onto their bank account because they were divorced and wanted to make sure that if something happened, mom or dad could easily access the money for the kids. Well, now mom and dad's applying for Medicaid, and Medicaid says, give us all those records. And maybe they're going to assess transfer penalties, even though it's just a joint for convenience. So joint ownership has its pros and cons. Insurance, who's our named beneficiaries on our insurance policies? You know, one of the things that we are going to talk about momentarily is how to use insurance and retirement accounts to our benefit. Who are the designated beneficiaries on those retirement accounts? And do we have any payable on death? We want to make sure that all these things align with our estate plan as a whole. Check on your power of attorney. Is it durable? We talked about that. But all powers of attorney are not created equal. There are good powers of attorney and there are really bad ones. So I'll give you an example. In New Jersey, if your power of attorney does not give you the power to gift or create trusts, you don't have it. And I use that power a lot to engage in crisis asset protection in a Medicaid land. So if your power of attorney doesn't have it, my answer to you is I can't save you any money without asking a court in a guardianship proceeding if we can do that. So I'm going to try, because we're running out of time and I want to get to retirement assets and charitable giving. So I'm just going to skip a few slides here to get to this really important point. So retirement assets, so IRAs, 401ks, unless they're a Roth where you've already paid your income taxes on contribution, these accounts are income taxable, meaning if you take a distribution from your IRA or 401k, there is an income tax liability. Now, you can pass an IRA or 401k to certain designated individuals, designated beneficiaries who are permitted to stretch or take out the minimum from these accounts over a lifetime. Surviving spouse, minor child is a limited period, a disabled or chronically ill individual, or an individual not more than 10 years younger. Anyone else, so if you just designate your child as the beneficiary of your retirement account, they're going to need to pay income tax on those distributions, and they got to take the whole thing out within 10 years. That's a recent change within the last few years, that anyone else that's not falling into that category below, those categories below, must take out the entire account within 10 years. And they got to take required minimum distributions. So by way of example, in this case, we had a $500,000 IRA that had to have required minimum distributions and totally distributed within 10 years. In that situation, there's a tax of $275,000. That's a lot of tax. But if you're considering charitable giving, you want to give back to your community, one of the best assets that you can use is a retirement account. And the reason for that is that there's no income tax to the charity. So instead of paying $275,000 on your $500,000 IRA at the end of the 10-year period, in this case, there's zero tax over the 10-year period, and the charity nets $815,000 as opposed to the, I'll go back a slide for a second, as opposed to the much more limited amount, the $448,000 that the beneficiary, an individual beneficiary gets. So we're almost doubling the money by leaving it to a charity as opposed to an individual. So if you are inclined to engage in charitable giving as part of your estate planning, retirement assets are one of the best places that you can do it. Another important thing to understand is inheritance tax. Here in New Jersey, we have the inheritance tax. So if you leave assets to someone other than a bloodline family member, so a spouse, child, grandchild, you leave it to someone else. friend, niece, nephew, sibling, they pay an inheritance tax. And another exempt is charity. So if you have individuals that you intend to benefit in your estate plan that are not what we call Class A beneficiaries, you are better off leaving those people life insurance, because life insurance is not inheritance taxable, and taking those retirement accounts and leaving them to charity. Because not only does the charity not pay an income tax, they don't pay an inheritance tax either. So with that, folks, I have tons and tons of resources on porzioplanning.com. You can go there. There's all of our webinars are posted there. So you'll see myself. You will see Deirdre, who is unfortunately unable to make today's presentation, but we have tons of webinars that we can use, that we have provided and put on our website. And with that, I have a few questions in the chat. I am going to look at a couple things here. So if you have long-term care insurance, do you still need to protect your assets? And the answer is maybe. It depends. That's my favorite lawyer answer, I know. It depends on what your policy says, right? Because some long-term care insurance policies are a 2-year policy or a 5-year policy. Some policies will cover $200 a day when the cost of care is $400 a day. So the answer is maybe. I would say to you that if you have a long-term care insurance policy, you can still have a consultation with an elder law attorney who can then do the analysis for you, right? That's what I would do. I would look at the policy and I'd say, here's how this will play out if you should need long-term care in the future. So I would say just have it looked at, because maybe it's good enough, maybe it's not. It would depend on your policy. Someone made a comment, New York State has changed its Medicaid law 3 times in the last 10 years. Yes. New York State is much more generous in their asset protection than we are here in New Jersey. And they are in the process of instituting a look back that they did not previously have. So yes, New York is changing and it's constantly a moving target. So I think that is all the questions that were in the chat and the Q&A. So if anyone has anything else, feel free to put it in. Otherwise, I hope you enjoyed it. I hope you learned one thing. That's always my goal.
Great. Thank you so much, Ryan. And thanks to all of you for joining today. We hope you found the presentation valuable as you develop your own plans. Any questions, feel free to reach out to us. So thanks again. Enjoy your afternoon.
Thanks, everybody.